Oh, so. Perjury. Yeah. See, I contend that if you claim you're a lawyer and you submit a filing, including in your own case or on your own behalf, and you know that the transcript from the court and the official record of the proceeding has been materially altered, that you're committing perjury. And that you are trying to also engage other people in the proceeding in the course of committing perjury, up to and potentially including the judge or the justices involved. And if you do something like put another filing on there, including what's supposed to be a court record, and the court record has a date that's backdated it so that it replaces or swaps out securities that were set up, including some form of surety connected to a case that was filed, or a notice that was sent out prior to the actual filing. For instance, you contact members of the legislature and you say there is a need for action in consideration of an imminent threat. And then the next day, you file something formally with the court, and then later, somebody else puts a transcript to overwrite you contacting those members of the legislature so that they have a completely fabricated and false record of a court proceeding, including one that has in it what appeared to be a demonstration of a pattern of materially altering court transcripts so as to leave available means by which to engage those fraudulent transcripts in acts of electronic warfare that could even be used to hack government databases, right? Especially in consideration of the fact that what you're doing is you're backdating a fraudulent court record to overwrite a notice of an imminent threat based on hacking. That's what I just saw. And so when the clerk of the court decided, for whatever reason, they justified it, to slander me by saying I was submitting an amicus curiae, or rather that I submitted a bill of exception in the form of an amicus curiae. What that did is, for one thing, altered the terms to make it look like the bill of exception, and what I needed to prove in that case was that I qualified insofar as I submitted an amicus curiae, which is not the truth. It was not an amicus curiae. A bill of exception has certain requirements in order for you to be able to meet the standard associated with it. To intentionally misrepresent what kind of a filing it is in the court transcript, and then to try to make me the pain point so that you can hack me for years while you engage in acts of slander, defamation, egregious breaches of ethics, and an effort to suborn perjury from everybody else involved in that case, including the more than 150 alleged lawyers who are allegedly members of the State Bar of Texas that did submit amicus curiae. Well, that brings the question up. Did they actually submit amicus curiae, or were all 150 plus lawyers also slandered? Here's this. Were any of those 150 plus lawyers slandered and or engaged in an act of suborning of perjury by trying to get them to misrepresent that they had provided support in a case that, and when they knew that the court transcript had been materially altered to provide fraudulent information that also engaged in acts of defamation against somebody who was actually elected to the bench? This is a very serious matter, and it's going on for a considerable amount of time. As a matter of fact, we're going to be coming up on 2 years, right? We're in the course right now of 2 years since that time frame. And so I cannot say at this moment that I know exactly when they backdated the stock associated with whatever other financial transactions were connected to that case, but they were substantial. And there was actually need to contact other entities about massive acts of not only electronic sexual violence, but also acts of other serious crime, including financial crime, connected directly to that case. And so when I contact another court in order to seek relief from the materially and factually incorrect information and the ramifications, and then I'm subjected to what I'm subjected to in that regard, it has a way of compounding. And so now what we have is a situation where all of that heinous, completely slanderous and unprofessional activity is overwriting what was an effort to contact members of both the Texas legislature and the federal legislature regarding an imminent threat concerning the people of Texas in regards to what was later and revealed to be a hacking event of a major credit bureau. Right? So I'm just trying to figure out what purpose does it serve to let people masquerade that somehow some purpose connected to jurisprudence, including professional consideration as a member of a bar association or somebody licensed to practice law, when in the course of so doing, you allow for a court transcript to be altered in order to slander a judge while also misrepresenting that a time frame during which members of the legislature were alerted to an act of electronic warfare that was acknowledged as having been involved with a hack of a major credit bureau was instead supplanted by another fraudulent court transcript that I haven't read it all yet. I am concerned is now rewriting that time period to engage in further acts of slander, including ones that have racial implications. Right? I mean, this has been going on for several years. And the thing is, that whole process started before I even came back to Texas. So if I, since November of 2016, have had that sort of situation going on, then what about all 150 plus alleged lawyers in the state of Texas that signed on as friends of the court in that case? Before November 2016, have they just been aiding and abetting a conspiracy to engage in egregious acts of racialized defamation of somebody who was elected to the bench, as well as acts of retaliation against me personally because I understood at some point the facts of the case were being misrepresented, and efforts concurrent to the case were putting other people into a situation of harm, and was completely denied due process, and in the course of seeking to pursue my rights to due process for myself, realized that there was factually incorrect information that was being allowed to masquerade as if it was official judicial process. How many of those 150 plus alleged lawyers lied? Just outright lied and presented completely materially and factually inaccurate information as a part of that sham of a proceeding that now also implicates each of them in serious securities fraud. Each of those documents would have been contextualized within, if nothing else now, at least two different proceedings before the Supreme Court of Texas that included allusions to or references to a court transcript that's been materially altered to have misinformation and present what appears to be not only acts of slander, but a process whereby one can engage in acts of hacking, including in connection with ongoing legal proceedings. It's been a long time. Somebody should have responded before now. Somebody should have done something remotely reasonable in consideration of this. Was the case involving the disciplinary proceeding regarding Robert S. Bennett allowed to be sold? Was that case allowed to be sold and or made available for use in a direct or derivative proceeding in a court of jurisdiction outside of the United States? including as a product, including as a product in an educational context,